Good afternoon, everyone. It's a pleasure and an honor to welcome you this afternoon to discuss on the interesting issue of the right to freedom of conscience, and more precisely, the right to conscientious objection in the field of medical practices. It has been a long time that we have been discussing with the special rapporteur on the specificity of freedom of conscience as distinguished from freedom of religion. And this is an underexplored issue. What is, per se, freedom of conscience? What is conscience? One of the fields where we can explore this issue is precisely when it comes to conscientious objection. You do not need to be part of a religious group or to hold a religious belief to have a conscientious objection. So what is this conscientious objection? Can a medical doctor, a midwife, a nurse, or a pharmacist be coerced to take part in an abortion, a euthanasia, or in assisted suicide? Can they be sanctioned for their refusal to take part in those practices? Can they be dismissed by their employer or denied access to the profession if they refuse to take part in a process aimed at ending a human life? Can a hospital, founded and run by a religious community, be coerced to practice abortion, euthanasia, or assisted suicide? The answer is clearly no. They cannot be coerced nor sanctioned. There is quite a unanimous consensus in both national and international laws recognizing and asserting the fundamental right to object practicing in a process aimed at voluntarily ending a human life. This right is inherent to the one of freedom of conscience. However, some people and states refuse recognizing this conscientious right, affirming in substance that if abortion is legal, no one shall be entitled to object. The personal conscience shall not prevail over the legality. Therefore, both medical practitioners and institutions shall accept to accomplish any practices once they are legal. According to this vision, the ultimate criterion of justice is not the conscience, but the law voted by the majority. And here lies the difficulty. Is it the law or the conscience that is a better indicator of justice? Normally, the law pursues justice and enlightens the conscience of the individuals, so that both the individual's conscience and the law are ordained to justice. They may not contradict, but work together, so that the individual conscientiously accepts to implement the law for their individual and common good. The problem arises when individuals have the clear and serious conviction that an act prescribed by a legitimate authority is not good nor just, but evil and unjust. Evil and unjust at such a degree of gravity that they cannot take any part in this act without losing their self-esteem or dignity. This problem is serious because it questions the very justice and goodness of the order, and ultimately of the law. A fair democracy should respect these questionings. The right to conscientious objection has long been claimed by individuals and groups opposed to killing and to taking part in military activities that may lead to the voluntary killing of other human beings. This right now is well established and recognized both in international law and in the legislation of most democracies. More recently, along with the depenalization in some countries of the practices of abortion or euthanasia, medical practitioners and institutions have also asked for, and most of the time been granted, the right not to take part in those practices. When we ask if an individual can refuse to take part in such practices, we should also reverse the question and ask if the society can coerce an individual to take part in such practices. To answer this question, we have to understand the fact that the liberal societies function with a double level of morality. The social level is said to be tolerant, whereas the individual level can maintain moral judgments. Liberal societies want both to be tolerant and to respect individual freedom and autonomy. Those societies are legalizing those contentious practices in a spirit of tolerance. The society shall not make a judgment on personal behaviors. It is up to the individuals to decide if they want to undergo abortion or euthanasia. Within such society, most individuals will not oppose the legalization of those practices, considering that they have no legitimacy to limit someone else's freedom. Therefore, they will accept or tolerate abortion or euthanasia. And this is one of the main arguments in the debate. Why should you prevent someone else from ending his life or her pregnancy? Who are you to judge and to deny someone else's freedom? You shall be tolerant because it does not change anything in your life and it does not force you to do the same. Most of the time, it is true. It does not change directly your life. But the fact is that sometimes it does change something in your life. When you are the one compelled to accomplish the contentious practice, if you are the doctor, the nurse, or the director of the hospital, it does change something in your personal life. It also changes something in your life if the school of your children starts teaching that those practices are good. The same doctor, nurse, or director may not contest the legalization of those practices because they want to be tolerant. But at the same time, they personally absolutely refuse to take any part in those practices. So they expect that society will also be tolerant towards them, as they are asked to be tolerant towards those who wanted those practices. It would be unjust to, on the one hand, obtain the legalization of contentious practices in the name of tolerance, and on the other hand, to be intolerant once those practices are legalized towards those who maintain a moral judgment. If a society wants to be just and tolerant, it has to accept that the individual makes conscientious judgments on their personal behavior. And it is for the society not only to refrain from coercing and from sanctioning those who refuse to take part in a process aimed at ending a human life, but also to protect them against discrimination. Too many medical doctors, practitioners, are discriminated against in their career or in their studies because of their position, because they want to uphold the old Hippocratic oath. However, the matter of conscientious objection is often presented as complex. Yes, it is complex if we look to the matter from the subjective viewpoint of the individual conscience. Why the respect for conscience requires that the convictions of an individual may prevail in some circumstances over the legal order. There are answers to this question. They go deep in morals and philosophy. But differently, if you look to the matter from the viewpoint of the practice at stake, then it becomes clear. Voluntarily ending the life of a human being is evil, even if society sometimes finds it justified to tolerate it. Therefore, no one shall be coerced to do it, nor sanctioned and discriminated against for refusing to terminate the life of a human being. In order to deepen our understanding of conscientious objection, to clarify and to exemplify this matter, I'm very pleased, after those remarks, to give the floor to three distinguished panelists. The first panelist will be Professor Heiner Bielefeld, the current UN Special Rapporteur on freedom of religion and belief. You propose to deepen the understanding of the right to conscientious objection within understanding of the right to freedom of conscience.